Hey, good afternoon, good morning, and good evening, everybody. Really appreciate you tuning in today. I'm Michael Barker from McGuire Woods, an estate planning lawyer coming to you live today from Richmond, Virginia. Really honored that you'd take some time today to join us for this third series in the McGuire Woods seminars. If you haven't seen the first two, really encourage you to go back and take a look. They are recorded and available for your perusal. Megan Hubbard, 2 Thursdays ago, did a really nice talk on settlor's intent and no contest clauses and some of those related trust administration issues. Last Thursday, Michelle McKinnon, Brad Reidelhoover did a really good talk on best practices for running a family foundation, a private charitable foundation. And today we're going to talk about the really sexy topic of estate administration. You probably saw that the title that we've given today's talk is Modern Problems Require Modern Solutions. Some of you of a certain age might recognize that as a reference to the Dave Chappelle show and his famous or perhaps infamous parody political ad, which offers hilarious fake solutions to real problems. I, unlike Dave Chappelle, will not be telling you that the key to the U.S. healthcare crisis is fake Canadian ID cards for all Americans. Hopefully today we'll talk about some real issues and discuss some real best practices. I'm confident I won't be as funny as Dave Chappelle, but we'll try to keep it light, keep it interesting. I'd like to give you some trends in the estate administration world. I'd like to talk about what's new and what's modern. This is certainly not a hot topics presentation in any way. Sort of take you back a few years and then try to give you some themes, aggregate some issues together to draw some conclusions. Obviously, estate administration is a really broad topic, right? We could talk about things like what do you do when you find the guns in the house, or things like how near to a body of water can you bury a body? Or things like, did you know that the IRS can't accept an estate tax check over $100 million? Obviously, we can't cover everything, so we'll try to focus on a few things. So what's different in the modern estate? I think lots of things. Maybe here's a few key ones. One is, perhaps somewhat obviously, much higher estate tax exclusion amount, right? We've got higher exemptions. We've got much fewer estate tax returns being filed. And so because of that, we've got the increased value, both literally and figuratively, of the DSU. So portability becomes a big issue now. We've got much higher interest rates than we've had historically, or at least in the recent historically. Is that going to portend a return of the Gregan loan? I think so. I think also anecdotally along with that, we're seeing increased illiquidity in various estates. And I think that has some very real impacts in how we administer estates. And obviously, we're seeing a lot of demographic changes. More estate administrations are coming. As the populace ages, we all know what that leads to. So I think we've got to be prepared for this topic. And if you're still using your old estate administration playbook, you might need to update your playbook. You know, there's that 1980s commercial that says, like, this is not your father's Oldsmobile, right? I don't think we're in your father's estate administration right now. And I should say before we really jump in, I'm a big believer in the collaborative approach to the extent we can do it. I know it's not easy in this context, but there is sort of a Q&A chat box. And if you're interested in leaving some comments or questions, I will have access to those, and we can perhaps comment on those and get to some of those if there's time. Okay, so where should we start? Maybe we'll start with the higher interest rates. I think that's a good place to start because it really is a significant shift in the way we're thinking about not only estate planning, but also estate administration. Modern estates exist in this world now with higher interest rates than we've seen in a while. If you were to look at a recent history of interest rates, say like 2019 to 2023, you'd see that for instance, the AFRs were in the gutter for all of the pandemic years, below 1% for most of that time. You know, those were the good old days when the rates and the markets made us all look like geniuses for rolling grats around. And then in the estate administration context, we got a lot of benefits there too. Now, if you were to take a little bit of a longer history and look at AFRs, call it for the last 15 years or so, maybe 2008 to 2023, again, almost all of those years are in absolutely historic lows. The midterm rate's at 2% for most of that time period, and in a really rising market. And that's meaningful when we're talking about trust funding and those types of issues. So now if you take a really long term or a longer term look at the history of rates, say going back to the 80s, now you're talking about 15% mortgage rates. You're talking about a lot of really high rates. So in today's context, maybe you would say, this is still historically low, even with the rises that we've had. And not only interest rates, but inflation rates. Between 2000 and 2020, the highest rate of inflation was in 2008. Perhaps that's not surprising, and it was at 3.8%. And the lowest rate of inflation during that period was 2009. Again, perhaps not surprising, but that was a negative inflation rate. In 2022, the rate was over 8.5%. That's more than double the highest rate of inflation for the prior 20-year period. Haven't seen that rate since the late 70s, early 80s. So the old normal versus the new normal, we've got a 5% 75-20 rate. That was the old normal. Then there was sort of the 2% new normal. And I think we're sort of in the world now where we're wondering if everything old becomes new again, right? I've read that there's nothing new under the sun. And I think this shift to higher rates really takes a shift in our thinking, right? What seemed obvious, like rolling grats around, now requires a lot more thought, a lot more analysis. So if we have to shift our thinking, what are we really thinking about? And again, in the estate administration context, I think it's Gregan loans. Let's level set for a minute. What's a Gregan loan? We're talking about a third-party loan structured with a promissory note that has a couple of features. One, it's got a fixed interest rate. And two, we have a prohibition against prepayment. And we'll talk about why in a little bit. So the goal of a Gregan loan is twofold. One, it's obviously to obtain cash to pay the estate tax that's due 9 months after date of death. And two, importantly, to reduce the total estate tax due by deducting the full interest amount as a cost of administration under 2053A. So I really think that the Gregan loan currently is an underappreciated technique. Certainly not as sexy as estate tax deferral under 6166, but it can be a really powerful tool when rates are high enough. We haven't thought about it much in the last 15 years because rates were so low that the interest deduction wasn't going to be but so significant. Now, if rates continue to hold or if they continue to rise even perhaps, I really think you're going to see more and more Gregan loans. Can be a really powerful tool, especially in states that have their own state level estate tax, because 6166 is really hard in those contexts. Think about jurisdictions like Maryland, DC, New York, Illinois, Connecticut, others. The regulations under 2058 say that the deduction for state estate tax can only be taken when paid, of course, right? Which means that the estate tax deferral under 6166 gets really complicated, too burdensome, constant recalculations, having to ask for money back from the IRS. It's really hard. So to avoid it, I think an easy alternative is to use a Gregan loan to provide the funds to pay both the state and federal estate tax, and from a state context, getting the deduction up front. So again, a really powerful tool, but only when done properly. It's like anything, you got to follow the rules, and there are some complex rules and considerations that I think are worth discussing, because I think it's important to show you sort of where the contours are and what you can and can't do, or should perhaps and shouldn't do with respect to a Gregan loan. For those of you keeping score at home, we're on page 71 of the materials, which I think you can download from the site. The Gregan case itself, I think, is a great place to start, because the assets in Mr. Gregan's estate were primarily of stock in a closely held corporation, right? That's a fairly common outcome these days. As I say, I think we're seeing the modern estate is more and more illiquid. Mr. Gregan's estate had very few liquid assets, and so it needed money to pay the estate tax. And the estate, as you can imagine, did not want to sell interests in the closely held businesses to pay the tax, right? Perhaps a fire sale or not being able to maximize value. So they borrowed funds. They used a 15-year promissory note. And because it was the 80s, they used the prime interest rate, which at that time was 15%. And importantly, all of the principal and interest of the loan was to be repaid in a single balloon payment at the end of the term. And like I say, the loan agreement contained a prohibition against early repayment. So when that happened, then the estate requested and obtained the approval of the local probate court for the personal representatives to enter into this loan. I don't think that's certainly a requirement, but I think it was helpful in this context, being the sort of the paramount case here. Then, when filing the 706, the estate deducted the amount of the single interest payment that was due upon maturity, and they deducted it as a cost of administration, right? The interest rate was so high and the term was so long that the interest made a significant dent in the amount of the estate tax due. So as you would expect, the IRS disallowed the interest expense, saying that the repayment was too uncertain, maybe the parties' relationship was too close, was it really a bona fide debt? But the tax court ruled for the estate and held that the amount of interest was capable of calculation, was not vague, and the entire amount of the interest was deductible as a cost of administration, which is a pretty amazing outcome and has been the law now for 35 years. The IRS quickly reacted to Gregan, and in '89 issued a litigation memorandum, essentially giving its agents some guidelines. And in that, the IRS does some interesting Jedi mind tricks. First, they say, well, our position has always been consistent with the Gregan case. Well, first of all, how could that be? Because they challenged Gregan. That was the whole point of why we were in the tax court. But the IRS then clarifies its position and says, interest on the indebtedness is deductible as an estate administration expense if the indebtedness is properly incurred to enable the estate to pay estate taxes for the purpose so you don't have to do a fire sale on your assets. Well, then they clarify that in order to be deductible, it has to be certain to be paid, and the amount of the interest has to be subject to reasonable calculation, I think is the term they use. So they just said in Gregan they didn't think that the estate itself, that those tests were met, which is probably not quite necessarily accurate, but is where they were. So then they went on after the memorandum, and the IRS issued some more guidance that talked about, look, the loan has to be bona fide. That's key. It's got to be a bona fide loan. Financing between related entities is going to be subject to stricter scrutiny than sort of an arm's length loan from a bank or a third party. Because if it's not real, it's not going to get a deduction, right? The transaction has to have real and actual substance. So the IRS says, look, we're going to audit more carefully if there are unusual financing techniques, if we've got unsecured loans or unnecessarily high rates of interest or loans with extra long terms, so you're juicing up the interest expense. We're going to look at all that pretty carefully. And second, the IRS said, and we're also going to look at what's the lender doing. Is the lender properly treating the interest as income on their end so that we actually have substance and accuracy in how it's being created on both sides? So I really think in the last 35 years since the Gregan case came out, the law has developed really well to demonstrate, one, that the devil's in the details, and sort of two, that we can put a little more meat around the bones about what some of those terms mean. There were some private letter rulings that came out in the late 90s, early 2000s that we have in the materials. I think that's page 73, that were favorable rulings approving the interest deduction. In those two PLRs, we had sort of very conservative, plain vanilla terms of Gregan loans. The loan was made by a commercial bank, so you've got that economic substance, you've got that bona fide third party. They had 7-year terms, right? That's pretty short, so it didn't feel too long. You had annual payments of principal and interest, not the big balloon at the end. And the note had the prohibition against prepayment, so it was easy to calculate the total amount of interest. So again, a very conservative approach, and they got the outcome. They wanted. There's a question in the chat that's a good one that says, does the Gregan loan have to be secured by the stock of the closely held corp? So good question, and I think we'll talk about it a little bit more in a second. The short answer is, your question says have to. No, it doesn't have to. There doesn't have to be security. I think having security on the loan is a very good factor in demonstrating that you have a bona fide transaction. Now, does it have to be secured by the company? No, it could be secured by something else. But I do think security is probably a best practice, though certainly not required. So I gave you the good. I gave you the sort of do a conservative approach from those PLRs. So that's the good. What's the bad? There's a technical advice memorandum from the Internal Revenue Service from 2005 that disallowed the interest deduction on a Gregan loan. And I think that's helpful because it sort of shows you, okay, we know where a safe harbor is not the right term because it's not quite that, but we know what a safe conservative approach would be. What's not going to work? In the 2005 TAM, you've got a decedent who forms a limited partnership, like our clients do, contributed his assets to the partnership in exchange for partnership interest, like our clients do. Mostly marketable securities, bonds, cash, fairly liquid stuff. But also there was some real estate in there. There was some notes receivable from estate planning and installment sales. So this looks pretty traditional on what we typically see with our clients. So after creating the FLP, decedent dies, the assets were to pass to his children, and they tried using a Gregan note. But what caught the IRS's attention was that one of the children was both the personal representative of the estate and the general partner of the FLP, right? And so when the estate borrowed the money, it was a 10-year note, prepayment prohibited, prime rate, LP interest pledged as security, had all those good facts, right? Straight up the middle conservative facts. But the IRS disallowed the interest deduction in that context because the service did not believe that the loan was necessary to the administration of the estate, right? Because the partnership had substantial liquid assets and the child was the co-executor and also the general partner, essentially the child could force the partnership to distribute liquid assets from the partnership to the estate. Of course he could. He was a general partner. So they could have paid the estate tax with a distribution as opposed to borrowing. So they didn't need the loan. And so the IRS says, look, the same parties on both sides of the deal, not a real deal, questionable whether they would have actually made the payments. The interest rate using prime +1 was maybe a little too high. But really what we're looking at is the loan wasn't needed. And so that's a key factor that has now become very clearly part of the IRS's analysis when looking at Gregan loans. Contrast that, Tam, with the Keller case, which came out, 12 years ago or so, out of Texas. In Keller, the court upheld the interest deduction, right? So this is another case of what it's like to win. And what's interesting to me is like the facts seem really similar to that 2005 TAM, but key differences that we'll talk about. So Keller was a really big dollar case. They initially paid, I think it was $150 million of estate tax, and then they later sued for a refund of a $60 million loan interest deduction from the Gregan loan. And the court ruled that the loan was necessary and appropriate for preserving the liquid assets of the estate and approved the deduction. And so the key differences between Keller and the TAM, you get a lower interest rate. Interest was paid at AFR instead of prime plus. Interest was actually being paid, right? In this context, again, in Keller, they paid and then sued for a refund. So now there was actually time to demonstrate that they actually were following the terms of the loan, which I think was helpful. And it had real economic impact because the parties between the borrower and the lender were different. So having non-identical parties without actual control, I think, really is key. And then just to, I think, narrow down a little bit more on what the contours are, there was the case called Stick, and Stick came out around the same time as Keller from the tax court. And in Stick, the tax court denied the deduction. It was kind of an easy one because the estate tax return showed that the estate owed like $1 million of estate tax. And the return showed that the estate had $2 million plus of liquid assets. And so the IRS said, hey, there's no need to borrow the funds, right? Need is key. So because the loan was not necessary, they didn't get the deduction. The IRS, I think you might say, channeled the words of the great American philosophers, the Wu-Tang Clan, and said this was definitely not necessary. So not all cases are quite as clean, though, as the Stick case. The Hughes case out of California was really interesting because Hughes was the founder of that company Herbalife, which was allegedly a pyramid type of scheme. And when Hughes died, he died young of a drug overdose, I think. His estate was really illiquid because they hadn't done planning and the Herbalife value was high. And so the estate held these interests in these various LLCs that owned the company, but the estate couldn't compel distributions. And so the IRS approved a really large loan with no payments of any kind due for 25 years. And it was like 9% interest and a huge deduction. I think it reduced the estate tax by 150, 160 million bucks. And interestingly, the court in Hughes thought that it was really a key fact that the lender was a third party. And the lender was technically a third party, but it was Mr. Hughes's lawyer that was the lender. I personally would love to be in a position where I could loan my clients 50 million bucks, but I'm not in that position currently. So I think we've hit Gregan pretty well. One more thought before we move on. You know, the Democratic leadership in Congress looks at Gregan loans from time to time, right? The deductions are considered by some to be easy loopholes for the wealthy to reduce their tax burden. So last year, summer of 22, the IRS issued some proposed regulations under 2053 to curb the interest deduction. The idea of those proposed regs is that they would require a present value calculation of the future interest payments. Now, as the law stands, you get to deduct, as I've said, the whole amount of the interest that'll be paid. This says, hey, it's pretty easy to do present interest calculations on what is X dollars 15 years from now worth today in terms of a deduction. And so that's one focus. And then the proposed regs, following some of the case law, really try to push a little bit harder on the necessity rule to make the necessity for the loan a key piece of the law and not just part of the case law analysis. So again, these proposed regs are not the law yet, but I think we'll keep a very close eye on them because the likelihood is, I expect, is that they will at some point become final regs. And even if they don't become final regs, don't be surprised to see the issue, pop back up from time to time as Gregan loans get looked at. But in the meantime, I think a fantastic opportunity in being thoughtful about using higher rates to our advantage. Let's talk about a different topic. I said that I think that one modern trend in estate administration is philanthropy. We're seeing big clients going big on big charitable giving. I think thus the need for Brad and Michelle's talk last week on family foundations, because there is very strict scrutiny coming out of the IRS on charitable deductions, right? It's a high hurdle, and it's harder and harder and harder to get a charitable deduction these days. We're seeing more and more, not just in the estate context, but in gift tax and income tax context, the IRS strongly attacking charitable deductions in recent years. There's a long string of cases. In the estate context, when we're thinking about charitable deduction issues, and again, for those of you keeping score at home, I think we're on page 76 of the materials. just a reminder that on a person's death, the unlimited estate tax charitable deduction is available for assets passing to charity, right? That's 2055. But to qualify for the charitable deduction, the interest and amount that's passing to the charity has to be ascertainable as of the date of the decedent's death. So if a trustee is given discretion over whether or not to make a bequest to charity, then the charitable deduction is likely to be denied because you can't ascertain it or value it as of the date of the decedent's death. Let's talk about two cases. First, let's go back a generation and do one cautionary tale. Then let's come back to the modern estate and do another cautionary tale to show you two sides, I think, of the same coin that you've got to be careful about when dealing with estates with charitable gifts in them. So the Marine versus Commissioner case is a tax court case from 1991. And in this cautionary tale, the decedent gave the residue of his estate equally to two universities. Sounds really simple. But then, towards the end of his life, he signed a codicil that empowered his executor, in the executor's sole discretion, to compensate people who had cared for the decedent until his death, right? He's thinking primarily about caregivers, but the codicil was written really broadly that the executor had sole and absolute discretion to determine who was going to receive a gift among the class of persons defined to be somebody who contributed to the decedent's well-being. So interestingly, the bequests to these individuals had to be relatively modest. No single bequest was permitted to exceed 1% of the gross estate. And in fact, as a factual matter, the executor only made two such gifts, made a $10,000 gift and a $15,000 gift to two individual caregivers. And because the remainder was going to pass to the universities, the executor claimed a charitable deduction of multiple millions of dollars on the federal estate tax return. And the tax court in this case, as you're probably not going to be surprised to hear me say, held that the value of the charitable bequest was not ascertainable as of the date of the decedent's death, right? Because even though the maximum gift to each individual was limited to a small amount, the court said, but of course it's possible that, with such an open class, it's possible that there could be 100 of those 1% bequests, thereby wiping out the charities completely. So we can't give any charitable deduction, even though almost all of the vast estate went to charity to these two universities. And one thing I think is interesting, sort of as a footnote, perhaps filed under the category of too little too late, after the IRS denied the deduction, but before they took it to tax court, the estate went to state court and got a court order that limited the beneficiaries to the two individuals who actually received the bequests. So they sort of admitted that they knew what the problem was. And of course, the tax court did not find that step persuasive because they said, we know exactly why you did this. I think brownie points for effort, or in the immortal words of LA Dodgers legend Joe Kelly, perhaps a nice swing. But remember, only the value actually passing to the charity qualifies for the charitable deduction. So we got to be really thoughtful about the valuation of partial interests that pass to charity, because only the amount actually passing to charity qualifies for the deduction. So that can lead to some surprising results when the interest actually passing to the charity is valued differently than the valuation of that asset for inclusion in the gross estate. What do I mean by that? Take a look at the Warney case, tax court case from 2 years ago, page 78 of your materials. Mrs. Warney owned several closely held entities that owned real estate in California, and the operating of each of the LLCs, had some of the standard language that the majority interest holder had considerable rights, including the ability with the manager to dissolve the LLC. And the minority owners, had very few rights, as you would expect to see. And so Mrs. Warney's estate plan left most of the LLCs to her family members, but one LLC that was called Royal Gardens that had I think it was an apartment complex, she left that to charity. And at the time of her death, she owned 100% of Royal Gardens. And her estate plan left 75% of Royal Gardens to her family charitable foundation and 25% of Royal Gardens to her church. So on her estate tax return, she listed the value of Royal Gardens to be $25 million, and she took a $25 million charitable deduction since the whole LLC passed to charity. But the IRS challenged the deductions and said, wait a minute, y'all are always using those standard valuation discounts against us. This time, where are those valuation discounts? Shouldn't those valuation discounts apply to these LLC interests, right? The church was getting a minority interest in an LLC. It wasn't marketable. So standard discounting theory should apply. And the tax court agreed with the IRS. On the calculation of the estate tax, Royal Gardens should be included in the estate at its full value, right? Because for estate tax purposes, the value is what the decedent owned. So here, that's 100%. And the value of the asset as part of an estate is determined without regard to the later disposition of that asset, right? So when calculating the value, as I said, for inclusion in the estate, it's 100%. It's what she owned. But when calculating the charitable deduction, you look at what each charity actually receives. You don't value what the decedent owned, you value what the charity received. So you end up with 100% of Royal Gardens includable in her estate. And even though 100% of Royal Gardens is going to charity, 100% charitable deduction does not apply. The court applied, I think it was a 27% discount for lack of control, lack of marketability for the minority interest passing to the church, and applied a smaller discount for the majority interest passing to the family foundation. So with those discounts, $25 million passes to charity with only a $22 million charitable deduction, meaning that you ended up with $1 million of extra estate tax. So really important to make sure that we're paying attention to those issues, because, as I say, I think one of the trends we're seeing is more and more charitable deduction issues. So when you're filling out your 706s, when you're being thoughtful on the front end with planning, make sure that you don't end up as either a warnie or a Marine, because we don't want that. Shift topics to talk about portability. I said at the outset that I think the increased exclusion amount means that portability is huge right now, right? Portability is the ability to use a deceased spouse's estate and gift tax exclusion amount, right? So it's important now, almost perhaps more than ever, to get the benefit of portability, right? Especially with the potential that the exclusion amount's going to go down in the future. I tell all my clients, go ahead and marry that elderly man in the nursing home. Your kids will thank you later when you get the DSU. So the recent update that's worth mentioning here is, as many of you know, the IRS has now extended the timeline for filing portability returns to 5 years after the decedent's date of death. In 2017, you probably remember we got those rules that said, hey, we'll do a simplified procedure to ask for an extension of time as long as you're within 2 years of death. And if you miss the 2 years, you have to go get 9100 relief. So now that process, so that procedure extends the 2 years to 5 years before you got to go get 9100 relief. Suggests to me how much the government is sort of all in on portability, which I think we knew, because all of the requests under 9100 were getting approved. So I also think it's showing how hard it is for taxpayers to keep up with it, or perhaps said differently, how many times taxpayers were screwing it up. So in the revenue procedure from last year, the IRS said, there are so many of these PLR requests asking for extension. These requests are too much of a burden on IRS resources. So let's just give an extension from 2 to 5 years so we don't have to keep dealing with this. I think there was probably a PLR, at least one every month on this topic for the last several years. So perhaps not surprising that the IRS was feeling overburdened. The IRS now is saying you can use that simplified method, but again, as a reminder, it's only available if the executor was not required to otherwise file an estate tax return based on the value of the gross estate. So if you had an estate tax return due otherwise, then you can't use this extended 5-year period. When thinking about portability, if I'm ever talking about portability, or candidly, if anyone else is ever talking about portability, I have to talk about the Vose case. The Vose case is not breaking news, but I think it's key to our understanding of the future of estate administration and portability planning. And it's also just my absolute favorite case. It was the case that I'd been waiting for. I think it was the case that you all were waiting for, even if you didn't know it. And it's just such a lovely case, because anytime you're talking about estate administration, how often do you get to talk about blackmail, right? The Vose case out of Oklahoma is the question of what happens when the executor refuses to make a portability election. You may remember that the notwithstanding comments from the estate planning community, the regulations are clear that only an executor can file the portability return. There were a lot of people who said, hey, maybe a spouse should be able to file that return, since it's the spouse who gets the benefit of the DSU. But the Treasury Department, perhaps very smartly, said, yeah, but the statute is very clear. The statute says that only the personal representative can do it. So our hands are tied and we can't give you that relief in the regs. So only an executor can file the portability return. So in the Vose case, you've got the second spouse situation. Mrs. Vose dies, leaves her assets to her son, Mr. Lee, and his name, of course, was Robert E. Lee. And she left her assets to Lee and not to her husband. Before getting married, Mr. Vose signed like a really comprehensive and thoughtful premarital agreement. And like all of the premarital agreements we draft for our clients, it waived all rights to property, his right to serve as executor, and was a really thorough prenup. So Mr. Vose wanted Mr. Lee to file a 706 to elect portability so he could get the DSU, which I understand was fairly substantial in the case. And when Vose approaches his wife's son, Lee turns to Vose and says, well, what's it worth to you, right? Lee says, it's in my discretion on whether or not to file this return. I don't have to file a return. And remember, the cost would be borne by Lee in the estate administration, who is inheriting. So then Mr. Vose says, well, wait a minute, I will agree to pay for it. And I think, as you'll see, that meant a lot to the court, that Vose was agreeing to pay for the accountant to prepare the 706. So Lee still refuses. Vose sues him, and he seeks a declaratory judgment that would compel Lee to file the 706. Lee says, hey, Vose signed the prenup. He relinquished all his interests in the estate. What's he doing coming back for this? But the trial court rules for Mr. Vose and says, yep, Lee, you've got to file. And Lee knew it was coming, I think, because he appealed the decision the very next day. But then on appeal, the Oklahoma Supreme Court affirmed the trial court and ruled for Vose. The court said that DSU is a potential interest in the estate that only a spouse can have. And the court, sitting in equity, sort of thought about it from an equitable perspective and said, there is no harm to the executor, and there's great benefit to the surviving spouse. And so we've got to make Lee file this return. So they kind of said, look, his duty against waste extends to all interested persons and not just beneficiaries. Not sure that's true, but that's what the court said in this instance. They said he's got to preserve the estate from damage and waste. He's got a fiduciary relationship to the world. Of course, that's not the rule at all. This ruling expanded the scope of Lee's fiduciary duties broadly because to get to the outcome they wanted to get to. And the court also got around the prenup by saying it was signed before portability was even a thing. So how could Vose have made a knowing waiver? But that's a cop-out, every prenup has to necessarily waive unknown rights, right? Had Mrs. Vose won the lottery or otherwise come into some money, same concept perhaps? The court gets around that by saying DSU is not simple property like the prenup envisioned. DSU is something unique, it's something special, and the court's not going to sit here and tolerate unreasonable or self-interested fiduciaries, right? They didn't quite say the word, but it was clear they were thinking about extortion. So it's an interesting case because I think perhaps you might say they get to the right answer, but the court had to use some odd reasoning. Many of you may have known my mentor, Dennis Belcher, and Dennis had a wonderful phrase when talking about courts sitting in equity. And Dennis said that a court sitting in equity has one job. A court sitting in equity has one job, and a judge is going to look around the courtroom, find the son of a gun, and stick it to him. He used a slightly more colorful phrase, perhaps, but I think you get the point. And I think that's what happened here. The Vose case is phenomenal. It's also, for those of you that have young lawyers or new folks in your office who are just wanting to get their feet wet on some things, a really good summary and history of portability. So I would commend the case to your reading for that purposes. So what's next, right? This case and portability in this context, still new, not a lot of law on it, but I think we're going to see more Vose-like cases, right? Particularly now that the exemption is so large, it's a more valuable asset to fight over. So I think we're going to see a lot more of it. And what I'm waiting to see, the next one that I'm really waiting for, is the portability slayer statute case. Can you kill your spouse and still inherit her DSU? You might think not, but it's not simple property, and that's what the slayer statutes prohibit inheritance of. Okay, next topic. As I said, I think we're seeing a lot more business interests held in estates. Folks are keeping their closely held, or perhaps said differently, they're forming closely held before death. And so I think we've got to be really thoughtful about business transfer issues, right? When a modern estate is chock full of closely held businesses, limited partnerships, LLCs, corporations, and more clients are dying when owning them, I think we've got to be really thoughtful, not only in the management of the business after death, but in also thinking about trust funding or distributions to beneficiaries to make sure that we're not getting sideways with some of the transfer restrictions inside the document. Because the governing documents, you can make a lot of assumptions about what might be in there, but might not be right. In the estate administration context, I talk to clients all the time about the Jimenez v. Corr case, which is a Virginia Supreme Court case from, I think it was about 10 years ago, and sort of a really typical vanilla estate plan where things got sideways, so we're thinking about it a little bit. The short facts of the Jimenez v. Corr case is Mrs. Corr owned stock in a closely held corp. The shareholders agreement says she could transfer it to her descendants, really common, got to keep it in the family type of provision. Any transfer outside the family would be subject to the right of first refusal language, right? That's pretty common in what we see in most of sort of the family limited partnership context. So she left her stock in her estate plan to her son. Easy does it, right? Oops, she used a pour-over will. And the ultimate beneficiary was the son. But first, legal title had to pass to her Rev Trust. And who was the trustee of that Rev Trust? None other than the dastardly son-in-law. The son-in-law, not a descendant. And so the Supreme Court of Virginia held that the right of first refusal applied and that the assets, the stock did not pass to the son. Because legal title to the shares passed to a non-descendant. There's a really good dissenting opinion from Justice McClanahan that sort of criticized the majority opinion for elevating form over substance and reaching what she called an irrational result and saying, hey, look, if she could have done it through her will, can't she use a pour over will rev trust like everybody else? But that's a dissenting opinion. And from an estate planner's perspective, I really think about, there by the grace of God go I, right? This is, to the extent that there was a mistake and that the assets didn't get to the son, such an easy mistake to be made. But just a helpful reminder not to skip the small stuff and being careful with transfers, right? When you're thinking about transfers of business interests, you're often thinking about not only to whom, but often when, right? Businesses often have a ticking time clock. So much of estate administration is a ticking time clock. Even more important with a shareholders agreement. How often do you see within 90 days the member can elect to, or after my death, within a year, the parties can choose to do XYZ. Maybe it's a buyout, maybe it's a ROFR, whatever, can be hugely important. And when we're thinking about ticking time clocks in estates, we're often thinking about S-corps, right? S-corps are another matter where you've got to act pretty quickly when somebody dies. It's also a really hot and active area. There's an S-corp private letter ruling almost every month. And if your question is, why is that? The answer is because people keep messing it up. And we care about S-corps only insofar as the estates that we administer and the clients that we represent have them, but they're everywhere, right? And so S-corps can be hugely advantageous to clients. Avoiding double taxation of C-corps, even with the lowered C-corp rate, still can be really meaningful for a lot of levels. But in exchange for that tax benefit, there's some really strict rules. And one is that only individuals can own S-corp shares, except for qualifying trusts. That's the only exception, SBITs and QUISTs. But you've got to make the election, right? For a trustee, they've got to make the SBIT. For a QUIST, only the beneficiary can make the QUIST election. And you've got to make it 2.5 months for the SBIT election of a newly non-grantor trust. So strict are these rules, and so much pressure, I think, on trustees in the context of an estate administration when somebody dies. Because if you miss the election and you don't make the SBIT on time, you don't just blow it for the trust, you're blowing it for the entire corporation. So like Vose said that Mr. Lee had fiduciary duties to the world, which I'm not sure is true here, this is one place where maybe a trustee has ancillary fiduciary duties to non-beneficiaries and could be liable to shareholders. Could be disastrous from an income tax perspective on the corporation. So again, trustees beware. But as I've said to some very despondent clients, the modern trend in the modern estate is this is a great time to blow your S status. There are tons of PLRs, as I say, almost every month over the last 3, 4, 5 years where people messed up the SBIT elections for a variety of reasons, and they almost all seem to get the relief, even when there's really bad facts. And some of that is due to the fact that the statute is written in a taxpayer-friendly way, because you can get S-corp relief for an inadvertent blown election as long as it's inadvertent and you took steps to correct it within a reasonable period of time. And if you get the relief, it's not just prospective, it's retroactive relief. You get to be an S-corp since forever. I'll give you a couple of quick examples in the just to sort of give you some sense on as to how it works and things to think about when you have estates that have S-corps in them. Maybe a really plain vanilla examples from a private letter ruling from a few years ago in 2019, where a client created an S-corp, transferred some of the shares to the S-corp to a trust. The trust was a grantor trust. So for income tax purposes, the grantor trust is ignored, no S-corp issues at all. And then the grantor died. So it's no longer a grantor trust. So now you need an individual owner of those shares or a qualified trust. And the trustee forgot to make the SBIT election. You could see how easy that would be to miss with all that's going on. If that estate administration had a million other things, the company became a C-corp at the instant of the missed election. But the IRS said that it was inadvertent, right? It wasn't motivated by tax avoidance. They just missed it. As a father of two young boys, I am very familiar with the phrase, it was an accident, right? It was an accident comes up a lot. And in the C Corp context, it's all you need. The S Corp can say, I didn't do it on purpose. I want the relief. And you get pretty amazing outcomes in that PLR and dozens and scores of others. And what's interesting to me about that is that there is plenty of room to attack if the IRS wanted to be sticklers on this issue. How do you prove inadvertence? How do you prove you weren't playing games trying to see which would be better, C Corp or S Corp? What is a reasonable period of time to correct the blown election? IRS has been pretty taxpayer favorable on all of those things. And there's a good modern trend towards that we can rely on. Another missing of the election was a PLR from another separate PLR from 2019 where S shares were transferred to a trust and immediately it was a non-grantor trust and the trustee failed to make the election. And then to make matters worse, there were subsequent transfers from one trust to the other, I think through a decanting or something else. And those trustees also missed the SBIT elections. Everybody missed it. The trustees asked the IRS for relief, said we didn't mean to, and that's all that they needed to say, and they got the ruling that they are and always have been an S Corp. Give you a slightly different twist. There was a private letter ruling from a few years ago where a taxpayer created an S Corp, then transferred the shares to a family limited partnership. And contrary to what Mitt Romney might have us believe, partnerships are not people too, right? So that blew the S election at that moment. But once the taxpayers learned that it was a problem, they asked for relief within a reasonable period of time and the IRS granted it. What I think is fascinating about this ruling is that the time period for the starting of the reasonable period, it wasn't when they learned that the transfers went to the partnership. It's when they learned that that was against the rules, right? It's when they learned that that was problematic that they went and fixed it, and the IRS said that was fine. I used to talk a lot about a private letter ruling from 2018 that was a cautionary tale that I thought was scary for trustees because of how technical the rules can be. I said that, of course, only individuals can own S shares. One other rule about S shares is that there can only be one class of stock. And here, you had a governing document as to the S Corp shares that the operating agreement or bylaws or whatever it was had some common boilerplate language that the lawyer had stuck in there that provided for some sort of special allocation of gains and losses, which created a second class of stock. And so unfortunately, it was deemed to have multiple classes as soon as that governing instrument was signed, and there was a problem, but the IRS gave them relief all the way back. And maybe as to show you how favorable these rulings can be, the two classes of stock issue is not just for the unwary, not just for the people who didn't pay attention to the technical boilerplate. It can also be for people who do it intentionally, which I find to be amazing. There was a PLR that was released on tax day last year that had an S Corp with one class of stock. Then the owners went to the Secretary of State's office, modified the certificate of incorporation to expressly permit a second class of stock. Nothing inadvertent about that. The certificate was modified to include sort of a Series A preferred stock and then to have some common after that. And the preferred stock, as you would expect, gave the holders rights to first dividends and other things. That was clearly a second class. What's fascinating is then they sold the preferred stock to a third-party purchaser. And then after the sale, somebody realized that, oops, this was supposed to be an S. I think we've blown the election, people. So they went back to the Secretary of State's website. They re-amended the certificate of incorporation to authorize only one class of stock. And the IRS gave them the relief. We don't know what happened to the purchaser, but I think sort of just goes to show how favorable that can be. So in the last minute or so that we have, maybe I'll give you my 2 cents on S corps. When you read these rulings, you can see a couple of things. One, as I say, the rulings to fix it are favorable. It's not easy to fix it. It's not cheap to fix it. You got to hire a lawyer. You got to ask for a PLR. Those things are expensive. But your likelihood of fixing it is pretty good. But the other things you see is like how easy and how many ways you can blow the S election, right? If you've got a beneficiary who fails to make a quist election, you've got a trustee who fails to make an SBIT election, you've got an accidental transfer to somebody who's not a U.S. citizen, or an accidental transfer to a partnership, or a trust ceases to be a grantor trust when the creator dies. You got intentional or otherwise creation of multiple classes of stock. You just have to be, in the estate administration context, you got to be so careful. I think one of the first things you do when you're thinking about inventories and other things is, hey, are any of these entities taxed as an S? Get in front of the accountant and see if you can't put some extra highlighting on your to-do list on those topics, right? Because who does it fall to? Who's minding the store on that question? Is it the S corps lawyer or the S corps accountant who's in charge of making sure that that gets resolved? Is it the estate lawyer? The lawyer, maybe was it the estate planning lawyer? Was it the executor or trustee, or the executor or trustee's lawyer or accountant who should be doing it? Whose fault are each of these things? And maybe the sub question is, does it matter whose fault it is if you're either the perceived expert or the perceived deep pocket? So it's really easy to miss, but luckily, even though it's not an easy fix, you've got a pretty good likelihood of success in light of recent trends. So I think we're out of time today. Really appreciate your thoughts and attention to this. And as I said at the beginning, make sure you go back and check out Michelle and Brad's and Megan's talk as well. Thank you so much.